Okay, it's going. We're good. We're good. I just heard it.
Yep.
Okay, well, welcome back, everybody. I got to tell you, I feel like a complete moron, and I don't know how Brittany puts up with me. She's dealing with a triple Virgo over here. So you want to know anal? You're listening to one right now. I've had a lot of people ask me about the previous recordings. She's cleaning them all up, all the junk that I do up front. She's cleaning all the upfront stuff. The recordings are already at pCloud in the audio file, and we're going to shorten them up. The third one, last night's call, has been cleaned up completely, so it sounds beautiful. So thank you, Brittany, on that. The free conference call line is getting fixed, and I did send out an email, so you should be able to navigate through there a little bit. We're gonna get that fixed by Monday as well. But other than that, here's what's going to happen tonight. I've had so many people, probably in the last 2 days, ask me about Minnesota 220. I wasn't really going to do that until the last week because I was just going to go over the documents at that point towards the end. But I think it's fine to do tonight because after everything I've spoke about in the last 3 days, you'll start to see what Minnesota Rule 220 is actually all about. And maybe it's a perfect time to introduce it. So because there's so many people that are interested in Minnesota Rule 220, I'm going to go over that. I'm going to actually break it down. I've highlighted myself. By the way, everybody should be able to pull Rule 220 up off of pCloud. And also, I would advise you, it's one thing, when I'm dealing with Black's Law Dictionary, I would have those definitions in front of me myself. So I'm going to be using, let's see, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, possibly 11 legal terms out of Minnesota Rule 220, and then I'm going to expound on those because it's important that everybody sees what I see.
Hey,
now,
can I interrupt?
Yeah.
I'm gonna download Black's Fifth onto.
No, it's already there. It's already there.
Oh, okay.
And it's by itself. So all they have to do is look up Black's Fifth on a PDF. I mean, it's a PDF, and so they don't have to look through any other ones. It's right there. It's all by itself.
Okay, and it's searchable.
It's real easy. Yeah, it's a PDF.
Okay, cool. The one that I have is searchable. Okay, all right, cool. Okay, bye.
Okay, bye. So I'm going to give you a couple minutes. I want everybody to have the Minnesota Rule 220 in front of them. And this, believe it or not, this is going to be, everything's going to start to get clear as long as you know there was waste material left in the hospital, along with the title. As long as you know that, it's starting to sink in that this is all about whose property, it's all about private property. Whose is it and who can prove it? That's all this is. So just focus on that idea that something was left behind. So I'm going to get started with the Rule 220. And this is going to be really fun. It should open a lot of eyes. I'm going to read it first. It says, the Registrar of Titles is authorized to receive for registration of memorials upon any outstanding certificate of title, an official birth certificate pertaining to a registered owner, named in said certificate of title, showing the date of birth of said registered owner, providing there is attached to said birth certificate an affidavit of an affiant who states that he or she is familiar with the facts recited, stating that the party named in said birth certificate is the same party as one of the owners named in said certificate of title, and that thereafter the Registrar of Titles shall treat said registered owner as having attained the age of majority at a date 18 years after the date of birth shown by said certificate. So this, right off the bat, it says age of majority at a date 18 years after. So remember what I said last night about being frozen in time? If you do not do Minnesota Rule 220, there's no way to prove A, that you're alive, or B, that you've moved beyond the birthday. The birthday. I'll say it again. The birthday. We keep reliving the same day because we never actually start or begin the journey. We're frozen back there on day one. Pink Floyd says, we missed the starting gun. So here we go. I'm going to skip around a little bit as I go through this. But it says the registrar of titles. Let's go to registrar right now. That would be page, I believe it's 1154. Registrar. Right off the bat, the registrar of titles. Bottom right, page 1154 in black stiff. What is the registrar? It says an officer who has the custody and charge of keeping a registry or register. A registry or register. Person in educational institution in charge of registering students for enrollment. And this is where it gets fun. A person in hospital responsible for admitting of patients. Admitting of patients. Let me ask you something. Is mom, when she goes into the hospital to give birth, would she be considered a patient? See, that doesn't seem to be right to me. When a woman's in there to give birth, it doesn't seem like the word patient actually fits. But let's think about this for a second. A person in hospital responsible for admitting of patients. There is in your P Cloud a document called the Afterbirth as Legal Infant. The Afterbirth as Legal Infant. This document, a friend of mine from Ohio found. This is actually out of Ohio. So if you can dig that up real quick, I want to read this. And it's in your P Cloud. The Afterbirth as Legal Infant. Here's what it says. 3705.11, Report of Foundling Child. Whoever finds a living infant of unknown parentage shall immediately report such finding to the local registrar of vital statistics of the registration district in which the child is found on a prescribed form, which shall state date of finding. This is finding a child, by the way. Just like, the material that's left behind after mom gives birth to baby. A, date of finding. B, place of finding. C, sex of child. D, race of child. E, approximate age of child. F, name and address of the person or institution with whom the child has been placed for care. The place where the child was found shall be known as the place of birth, and the date of birth shall be determined by approximation. The person, superintendent, or manager of the institution with whom a foundling child is placed for care shall give such child a name within 10 days. and shall promptly report the name given to the local registrar of the registration district in which the child was found. The foundling report shall constitute the birth certificate for such foundling child, and Section 3705.01 to 3705.29 of the revised code relating to birth certificates or records shall apply in the same manner and with the same effect to such report. If a foundling child is later identified and an original birth record is found or obtained, the foundling report shall cease to be a public record. Such foundling report shall be placed in an envelope which shall be sealed by the department and shall not be open to inspection or copy unless so ordered by a court of competent jurisdiction. All copies of the founding report in the possession of the local registrar or the probate court, as well as any and all index references thereto, shall be destroyed. One last thing I suppose I should do is go to the word foundling. Foundling. I wasn't planning on foundling, but now that I'm thinking about it, a foundling is on page 591 of Black's. A deserted or abandoned infant, a child found without a parent or guardian, its relatives being unknown. Foundling hospitals, charitable institutions which exist in many European countries for taking care of infants forsaken. Remember what the first word from abandoned is, forsaken, by their parents, such being generally the offspring of illegal connections. Remember, I said last night that the state is the father of the maternal afterbirth. In other words, that's an illegal connection. No biological father. The state becomes the father of that child. So what I'm getting at is, right off the bat, it says the registrar of titles is authorized to receive for registration. This is what I do, people. I take something as simple as this one paragraph, and I find out exactly what it is they're doing. The word authorized. What's the root to authorized? Author. What's the root to authority? Author. What does an author do? Create characters, fictitious characters. Who's the author in the birth process? Mother is. When she puts pen to paper, she creates a fictitious character, a title, which is intellectual property. Remember, this is all about whose property is it and who can prove it. Author. Author, one who produces by his own intellectual labor applied to the materials of his composition, an arrangement or compilation new in itself, a beginner or mover of anything, hence efficient cause of a thing. Creator. I spoke about the creator yesterday. You want to lay claim to the entire world? Lay claim to the creator. Mom. Originator, a composer, as distinguished from an editor, translator, or compiler. Authority. Permission. Right to exercise powers, to implement and enforce laws, to exact obedience, to command, to judge, control over, jurisdiction. What does it say there? The registrar of titles is authorized to receive for registration of memorials. Who do you suppose authorized them? The only one that can authorize anything is the owner, the creator. So Mom authorized the registrar. Whether it's by default, by mistake, by leaving something behind and having it fall to the lost and found. Authority, the power designated by a principal to his agent. The lawful delegation of power by one person to another. Power of agent to affect legal relations of principal by acts done in accordance with the principal's manifestations of consent to agent. Consent to agent. Do you realize in the hospital that the birth process itself is considered an emergency? The birth process is considered an emergency. Why is that important? Because there's something called the emergency doctrine. The emergency doctrine is in Black's Law on page 469. Now remember, this is all the same thing. This is mom in the hospital. This is what they're doing. This is Minnesota Rule 220, broken down. The emergency doctrine, page 469, Black's Law. I'm going to read just the last paragraph. It says, in an emergency situation, by the way, remember situation? Situs? Place? In an emergency situation, when medical service is required for an adult who, by virtue of his physical condition, is incapable of giving consent, or with respect to a child whose parent or other guardian is absent, and thus incapable of giving consent, the law implies consent to administer emergency medical services. So when there's such a case, whether it's delivery of a baby or a child, a parentless child, it says the law implies consent. Everybody out there that's living through this afterbirth child, the one that's considered a foundling and parentless, every single American out there that is talking about not consenting, that is not relevant, because they're living through a character that's considered an orphan, a foundling child. And that foundling child does not have the power to consent because consent is implied. Consent is implied in the emergency doctrine. So again, what does it say right there? It says, with respect to a child. If you have not gained the age of majority, you're considered a minor. It's either major or minor. If you don't make it to the age of majority, you are considered a minor and subject to the emergency doctrine, and you have no right to not consent. The registrar of titles is authorized, in other words, author, by who authorizes it? Mother does, is authorized to receive for registration of memorials. What is a memorial? What, off the top of your head, what is? I mean, I know of only one memorial, one idea of a memorial. I don't use memorials except when I'm considering or thinking about funerals. A memorial to me is going into the cemetery and seeing a marker, a stone marker or something that is a reminder of somebody who is passed or missing or dead. That's what the stone is there for. It's to help us remember those who are no longer with us. What does Black's Law say about a memorial? Memorial is on page 888. I'm going to go really slow tonight. You're going to be able to breathe. A memorial. A document presented to a legislative body or to the executive by one or more individuals containing a petition or a representation of facts. Look at that. A representation of facts Is not the chorion a representation or sample of your DNA? Does it not represent you? It certainly does. It is you. So in the absence of you, if they have a sample of you, that's a perfect representation. Well, actually, it's not. It's an imperfect representation. Notice how they're also dealing with facts all the time. By the way, this is a government of fact. A government of fact which is called de facto. But look at this. In practice, this is memorial, in practice, a short note, abstract, memorandum, or rough draft of the orders of the court, from which the records thereof may at any time be fully made up. What does that mean? When you're a kid, when somebody says, you just made that up, that's kind of an interesting choice of words there. Records thereof may at any time be fully made up. In English law, that which contains the particulars of a deed, the particulars of a deed. I have to go to this. I have to go to particulars. Particulars is on page, let's see, there it is, page 1008, 1008. Okay, what does it say there? It says in practice, in English law, that which contains the particulars of a deed, etc., and is the instrument registered, as in the case of an annuity, which must be registered, an annuity. But look at what it says. It uses the word particulars. Page 1008, particular. Relating to a part or portion of anything. Relating to a part or portion of anything. Is not the chorion a part of the whole? Is not the chorion DNA a part of your kingdom? Your physical body. Biblically, they call that the lost lamb. Separate. Separate. S-E-P-A-R-A-T-E. It's separated from you. It's separate. Soul, single, individual. Do you realize that the birth record is actually for an individual? The word individual. In fact, first, middle, last is the legal name for an individual. First, middle, last. An individual. In fact, that'll be fun. I'm having fun tonight. Legal name. Legal name. Everybody's running. Oh, Kurt, it's illegal to use a legal name. Morons. Morons. Legal name. Let's find that. Legal name. Now, what did I just say? It says particular, relating to a part or portion of anything. Separate, sole, single, individual. Specific, local, comprising a part only. Partial in extent, not universal. Of or pertaining to a single person, class, or thing. But I'm going to go to the word individual here for a second. I'm actually going to the legal name because I'm going to tell you what the name of the individual is. Legal name, page 806. Under common law. Oh, Kurt, I want to live with the common law. I'm about to tell you that everything going on in your life is based upon the common law. But you need to be alive in order to invoke it. Under common law consists, this is legal name, consists of one Christian name and one surname. And the insertion, omission, or mistake in middle name or initial is immaterial. One Christian name and one surname is the legal name. And if there is or is not a middle name, or if the middle name is a mistake, But here's where it gets interesting. It says the legal name of an individual consists of a given or baptismal name, usually assumed at birth, and a surname deriving from the common name of the parents. Isn't that funny? So the legal name under common law is one thing, but it then says the legal name of an individual consists of a given or baptismal name, usually assumed at birth, and a surname. Well, what does that mean? It said consists of a given or baptismal name. Now, if I go to the legal term or, that's O-R, you're going to see something that you wouldn't believe. The word O-R means and. Oh, you're thinking it's one or the other? No, it's one and the other. So what does it say? The legal name of an individual consists of a given and baptismal name, usually assumed at birth. By the way, what is the word assume? How do you learn how to spell assume? It makes an ass out of you and me to assume anything. It consists of a given and baptismal name, usually assumed at birth, and a surname. So, given name, Curtis. Baptismal name, Richard. Surname, Kallenbach. Curtis Richard Kallenbach is the name, the legal name of the individual. It's not a legal name under common law. It's a legal name of the individual, and what's on the birth record? The birth record is first, middle, last. It is the name of an individual. What is an individual? Go back to the word particular, relating to a part or portion of anything. So the individual name is identifying a part, not the whole. Curtis Richard Kallenbach identifies a piece of something, a part of something, a portion of something, comprising a part only. So that's why I'm saying the chorion is a piece of me, and the chorion has a name. Curtis Richard Kallenbach. It's called an individual, or the lost lamb. So where was I? This is how I get off track. I'm back at memorial. Remember, it says the registrar of titles is authorized to receive for registration of memorial. Memorial. We're still on memorial. Because it says in practice a short note, abstract, memorandum, or rough draft of the orders of the court, from which the record thereof may at any time be fully made up. In English law, that which contains the particulars. There's your English law particulars. Individual contains the particulars of a deed, etc., and is the instrument registered. And is the instrument registered, as in the case of an annuity, which must be registered. But look, here's the word. As soon as I read that, what did I see? Memorial, in practice, a short note, abstract, or memorandum. And I went, wow, there's the word that I want to see. I want to know what the memorandum is. I want to know what they're doing here. Remember that when you read these terms, that anything in that paragraph is possible. What they usually do is they throw out so much smoke, and there's one little thing in there that actually it brings you right back to the afterbirth. In almost every single definition, I can bring every one of the words in here back to the black magic afterbirth, the one that the Pope claimed in 1302 in Unum Sanctum, the human creature. Memorandum, it's just to the left there. It's still on page 888. Look to the left side of the page. It says memorandum. To be remembered. Remembered. Now, I don't even know if remember is in Black's Law. I'm going to look right now. It's funny that I never tried to look it up in here. Remember. It is not. So Black's Law doesn't have remember. But because it's so important, remember what to remember. What is to remember? Again, if I was in your yard and I had an accident and cut off my finger in your yard. The finger is a member of my hand. It's a member of my body. It's a member. So now there's a finger laying in your yard. If they were to reattach it to my hand, that would be a form of remembering. What's another idea for remember is to do what? Is mentally recall something in the past, to remember. How many people recall the part of them that was split off while they were a zygote? How about nobody? I can't imagine. See, the reason this is so funny is because it's really impossible to remember that that there's a piece of you missing. It really is unfathomable that anybody would actually go, oh yeah, I remember when a piece of me was split off right after fertilization. It's not going to happen. What you have to do is you have to recognize the fact that a piece of you is missing. And you need to reattach it or remember it. You need to claim it in order to be whole. But I'm going to Webster's real quick because I want to see what Webster says about remember. It probably says recall and all that. But to recall something, to recall it. If I'm sitting here in my chair and I left something someplace else, I could recall it, bring it back to me, bring it home, bring it back to here. To recall it, bring it back here. Just like the chorion, I have to bring it back into my existence. Remember. Defined. This is the first thing that pops up. Remember. To have in or be able to bring to one's mind an awareness of someone or something that has been that one has seen, known, or experienced in the past. Seen, known, or experienced in the past. Are you experienced with the chorion? Absolutely. It says to do something that one has undertaken to do or that is necessary or advisable. Used to emphasize the importance of what is asserted. I'm going to go to Merriam-Webster now and see what they say. This is to remember. The transitive verb, to bring to mind, to think of again, to bring to mind. To keep in mind for attention or consideration. If you think about contract law, isn't a consideration required? Isn't there supposed to be consideration in every deal that's made? Every lawful deal, consideration? Hey, if you leave a piece of you behind on deposit or as a security, isn't that a consideration? To remember, it says to keep in mind for attention or consideration. 4, to retain in the memory. 5, to convey greetings from. 6, to record or commemorate. Commemorate. Intransitive verb, to exercise or have the power of memory. To have a recollection, recollection, a recollection, to recollect, or remembrance. Always be thinking there's a piece of you out there somewhere that needs to be put back in its place, which is with you. Memorandum. To remember. To be remembered. Be it remembered. A formal word with which the body of a record in the court of King's Bench anciently commenced. An informal note or instrument embodying something that the parties desire to fix in memory by the aid of written evidence. Fix in memory. Fix in memory. Does anybody, have you ever met anybody in your lifetime? I'm 56 years old, and nobody in my lifetime ever spoke of the missing piece of me. And they've never spoke of the missing piece of themselves. The only way that anybody would ever know this is because there's a memorial for that event. There's a memorial that helps for you to remember the missing piece of you. But if you don't claim it, it's looked upon as being deserted, forsaken, abandoned. So you're allowing a piece of you to go out there and be in the public, to be a charge to the public. And remember the document that I read from last night, the High Court of Chancery, where it says the church wardens are actually entitled to your usufruct, the fruits of your labor, until you get out from under them, until you get out from underneath their care. And the only way you're going to do that is by gaining the age of majority and no longer be considered a legal minor, because that's who's taking care of that afterbirth, by the way. Who do you think created the birth certificates, for crying out loud? The Roman Catholic Church in 1933. This was all going on long before 1933. But the church created that bond. Here we go. An informal note or instrument embodying something that the parties desire to fix in memory by the aid of written evidence, or that it is to serve as the basis of a future formal contract or deed. Serve as a basis? What is the word base? We already know what it is. It's going to say foundation or grounds or something like that, but let's just look. Basis. Baseline. Base. Base. Low in place or position, inferior, servile, of subordinate degree, impure, adulterated, or alloyed. Base. I'm looking for something else here. Base. The bottom, the foundation, groundwork. On what grounds? Yells the judge. Bottom, foundation, groundwork, that on which a thing rests. Standing, people. This is your standing. If you don't have a body, if you don't have your own claim to your physical existence, the DNA, if you don't have that claim, you have no foundation. You have no ground. You don't exist. It says the locality on which a military or naval force relies for supplies or from which it initiates operations. Base. It's substance. 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 Back to memorandum. Under portion of statute of frauds. Providing that a contract not be performed within a year is invalid unless the contract or some memorandum of the contract is in writing and subscribed by the party to be charged or his agent. The word memorandum implies something less than a complete contract, and the memorandum functions only as evidence of the contract and need not contain every term, so that a letter may be sufficient memorandum to take a case out of the statute of frauds. Subscribed. What is to subscribe? It says, and subscribed by the party. What is a subscriber? A subscriber is an underwriter. Under, scribe, write. Subscribe is to underwrite. What is an underwriter? A guarantor, an insurer. This word is used in the statute of frauds as a designation of the written agreement or note or evidence thereof, which must exist in order to bind the parties in the cases provided. The memorandum must be such as to disclose the parties. Disclose, meaning to open. The nature and substance of the contract. The nature and substance of the contract. The consideration and promise, and be signed by the party to be bound. Bound. Isn't to be bound a form of bondage or his authorized agent? So let's go back up to the top of memorandum again. It says to be remembered. They're talking, and in the next paragraph it says a desire to fix in memory. Fix in memory. So let's do this. Let's go to memory. It's all on the same page, people. This is how you learn how the words can be applied to you, or at least to the cause of action. And remember, this book is telling a story. It's telling a story. If you understand where it's all going, it's pretty easy to find out how you get out from under it eventually. Memory. The word as used in Blackstone and other ancient authorities appeared to be synonymous with mind. Remember my little three-sided, my little triangle there? Mind, body, spirit. So mind, they're actually saying memory and mind are synonymous, whereas the word memory in modern times is used as a more restricted sense of recollection of past events, recollecting of past events, the recollection of past events. If you can't remember your arrival, I mean, how many people, and I've actually had people tell me they can, which I'll be honest with you, I think it's ridiculous to say, yeah, I remember coming out of the womb. I don't think so. But it says, in modern times, it is used as a more restricted sense of recollection of past events. Does anybody on this call remember being born? Well, it obviously occurred, but you can't remember it. So the only evidence of you coming here without, you can't be the witness, so somebody else has to sign on as a witness. So the event of your arrival, the birth record of your arrival. But they didn't record that, did they? They recorded it for an individual. It says of past events rather than the general state of one's mental power, mental capacity, the mental power to review, and recognize the successive states of consciousness in their consecutive order. In their consecutive order. You're out of order. What does that mean? It's Curtis Richard Kallenbach is my claim. Curtis Richard Kallenbach. Is that in the proper consecutive order? No, it can't be. Because my father is here before I am, so Kallenbach has to precede Curtis. My father has to be here before me. So even to lay claim to Curtis Richard Kallenbach is out of order. It's not the proper arrangement. Kallenbach, comma, Curtis Richard. Father, Son, Holy Ghost. Successive states of consciousness in their consecutive order. A to B to C, consecutive. Father, Son, Holy Ghost. Mind, body, spirit. Look at this word as used in jurisprudence to denote one of the psychological elements necessary in the making of a valid will. They're actually saying that if you are not of sound mind, you can't have a valid will. I don't want to do that. I'm sorry, but you're not of sound mind. But I don't want to do it. It doesn't matter what you want. Want and will. Think about this. If you don't have a valid, if your mind is being questioned and you don't have a valid will, then whatever you want for yourself is not relevant. It's the administrators that get what they want because you're not of sound mind. So it doesn't matter what you want because you don't have a valid will or contract, or the commission of a crime implies the mental power to conduct a consecutive train of thought. One thing leads to another, a consecutive train of thought, or an orderly planning of affairs by recalling correctly the past states of mind and past events, and the arranging them in their due order of sequence and in their logical relations with the events and mental states of the present. The phrase, sound and disposing mind and memory means not merely distinct recollection of the items of one's property and the persons among them who it may be given, but entire power of mind to dispose of property by will. This is so important, I can't believe it. It says not merely distinct recollection of the items of one's property and the persons among whom it may be given, but entire power of mind to dispose of property by will. So it says not merely, but entire. Why is it? Why am I really nailing that? Because the word mere, M-E-R-E, means mother. It means mother. And whenever you see it placed in front of a word, always think of it. Why would they use that? Most of the time it's not required unless they're stating a position from the mother. Merely is mother. In fact, as long as we're in the M's, let's just do this so you can believe me, because I don't really want to just be spewing this stuff out. Actually, it's only 1 page or 2 pages over on 891 at the bottom of the page. Mere, M-E-R-E, mother, grandmother, mother, daughter. And ventre samir, in its mother's womb. Mere means mother. So why are they using the word merely distinct recollection? Because they're choosing the one side of the equation that is pure mom. But they're saying that that's not the entire power. It's a portion, a piece, a part, but it isn't the entire. It says, but the entire power of mind to dispose of property by will. So if you're living through the mere individual, that's not the entire power. The reputation and name, good or bad, which a man leaves at his death. This is still memory. Legal memory. An ancient usage, custom, supposed grant as a foundation for prescription. It says a supposed grant. What are we taking for granted? What do we take for granted? That's my birth certificate. That's my birth certificate. We have taken that birth certificate for granted, as if somebody said it's okay for us to use that. Who's the only one that can grant us permission for that birth certificate? The church, because they're the ones that created it. Curtis Richard Kallenbach, remember early on where it says the registrar can create a name, but who creates the name? I don't want to go back to registrar. You can look it up yourself. Who's the creator of the name? See, there you go. It says, and the like are said to be immemorial when they are really or fictitiously of such an ancient date that the memory of man runneth not to the contrary. In other words, you can't remember, so how can you dispute it? Or in other words, beyond legal memory. If you realize that when somebody told me my birthday was September 19th, 1960 at 3:50 a.m. Anno Domini, I have to take their word for it because it's beyond my legal memory. I can't actually know that. It is truly hearsay. I was there, but I didn't have the mental capacity to know dates and times, things like that. I have to go by the paper that says, yeah, this event here, somebody arrived at this event. We're talking about Minnesota Rule 220 here. as one of the registered owners. It's the only way I can identify that point in time where I arrived on some place, some piece of ground in some state within the republic. And legal memory, or time out of mind, according to the rule of the common law, commenced from the reign of Richard I. But under the statute of limitation of 32, blah, 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 let's see what it says. Here it is. This is crazy stuff here, people. This was reduced to 60 years, and again, by that of 2 and 3 William, blah, 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 to 20 years. So 20 years, at 20 years old, you're supposed to ultimately have already claimed that birth record by 20. Here's where it drew my attention immediately, though. It says, in the American states. What the hell is that? It says in the American states. It didn't say in the United States. It said in the American states. What the hell is that? The American states consist of South America, Central America, and North America. That's the claim of Rome. That's the claim of Catholicism. That's the claim of Spain. Vespucci, the one that really discovered this for Spain. It says, in the American states, by statute, the time of legal memory is generally fixed at a period corresponding to that prescribed for actions for the recovery of real property. Real property. They're talking about land here, real estate, real property. But why did they use American states? Because they weren't talking about the United States of America. They were talking about America. Latin Catholicism. The claim by the pontiff. The human creature subject to Rome, the Roman pontiff. The American states. This is not the United States of America. This is the American states. You think that memorial doesn't describe something else? I mean, in 1933, when FDR said, today is a day of national consecration, they're talking about this ground. They're talking about this ground. It's been memorialized or consecrated. It was made holy, because it is. Your DNA is holy ground. It's the land of your spirit. It's the house of the holy. And they're claiming it for the church. They're claiming it for Rome, because you haven't gone back to pick it up. Minnesota Rule 220 allows you to do that. My God, where am I? I'm only on memorial? Shit, I better pick up the pace. The Registrar of Titles is authorized to receive for registration of memorials upon any outstanding certificate of title, an official birth certificate pertaining to a registered owner. You know what? The word is outstanding. Outstanding. Page 994. Outstanding. Let's see what that says. This is what I did for 7 years, people. This is what I did for 7 years. Outstanding. Oh my God, does it really say this? Of course, I already knew what it said, but that was for effect. Outstanding, page 994. Remaining undischarged. Now, when I say undischarged, most people are thinking of money, aren't they? Like the charges that are brought up in the courtroom. But what about when somebody goes into the hospital as a patient? How do they get out of the hospital? What do they have to be? They have to be discharged. You can't get out of the hospital without being discharged. Does the afterbirth ever get discharged from the hospital? How could it? It's a patient. In fact, if I go back to the word registration, and I'm going to do that right now just for the hell of it, registrar, page 1154, I have to do this. 1154, registrar. Okay. Why am I going back to this? It says, registrar, page 1155. Person in hospital responsible for admitting of patients. Admitting of patients. Is mom a patient when she's giving birth? I don't know, but I tell you what is a patient is that defective birth material that is left on the floor, that foundling child, that's a patient for sure. So they admit that patient. They register that patient. And that patient, it says, remaining undischarged. The afterbirth is never discharged from that institution. It's never discharged from that hospital. Remains undischarged. Remaining undischarged. Outstanding. So that afterbirth character, that afterbirth person is in the hospital your whole life. Goes on to say unpaid, uncollected. Hey, if there's a piece of you out there, don't you want to recollect it or recollect it? Don't you want to remember it, reattach it to you, pull it into your life? Uncollected as an outstanding debt. Outstanding debt. To who? It goes on to say, constituting an effective obligation. When set of stock, the shares issued less treasury stock. When set of checks, it means a check issued that did not clear the drawer's bank prior to the bank statement date. Existing as an adverse claim or pretension. Pretension? Not real? Existing as an adverse claim or pretension. Isn't that what's happening in the courts? Isn't there the courts are adversarial, but somebody's making a claim upon this afterbirth. That's an adverse claim to the true owner, which is you. And mom, because remember, you're the owner of the chorion, mom's the owner of the vessel that you arrived in. Mom is the owner of the maternal afterbirth. But you're 100% owner of the chorion. So who's making a claim? The people that claim. Just like if I cut my finger off in your yard, look at all the potential here. My finger drops to the grass in your yard. Okay, so now you and I don't know, I can't find it. So the finger's on your yard, your land. So the landowner has a claim upon my finger. That's where the finger is eventually found by the kid down the block that's mowing the grass. Now the kid that finds it has a claim on it too. But wait a minute, the bank, since the house isn't paid off, now the bank who has the lien on the house has a legitimate claim upon anything found on that ground. Well, according to 1883, the Treaty of Paris, the king has an allodial claim on America. You can see all the potential claimants to the finger that's laying on your grass. But there's only one true owner, and that's me. And all of those other claims fall by the wayside when the true owner makes the claim, a proper claim. All of the other claimants can shut the hell up because they don't have a leg to stand on at this point. There's no adverse claim. But again, I'm looking at outstanding. It says, existing as an adverse claim or pretension, not united with. Outstanding is not united with. What does it say in Minnesota 220? The registrar of titles is authorized to receive for registration of memorials upon any outstanding certificate. Outstanding means not united with. So something is separate from something it belongs with. It's supposed to be united. That chorion is supposed to be united with me. It was at one time united. While I was when I was a zygote, that afterbirth chorion was part of it. It should be reunited. It says, or merged in the title or claim of the party as an outstanding title. Until the title and all those pieces come back together, there's multiple claimants. We need to pull ourselves together. That's, by the way, the word, that means integrity. To have integrity is to be whole. Do you realize that the word sincere means sine cera, without wax. When somebody was chiseling some new stone piece of art and they made a mistake and they broke off something or chipped off something, what they would do is they would fill it with wax so it looked whole. But it wouldn't be whole. It was filled with wax. So when something was whole in and of itself, it was sincere or sine cera, without wax. That's when something is whole or complete. Outstanding, united with. So what I'm trying to do is become a united state. I'm trying to actually unite the states of existence, my states of existence. Me here now and that afterbirth chorion, which is someplace else, and it needs to be claimed by me in order for me to be whole, for me to be sincere. Upon any outstanding certificate of title, an official birth certificate pertaining to a registered owner named. Oh, I'm not going to use that name. God damn it, Kurt, that name's going to get me in trouble. Only if it's not connected to you. Only if you don't have a legitimate claim upon it. That thing is actually registered to your DNA. If you run away from it, you're running away from your very body, the very existence, your very existence. And a registered owner named in said certificate of title showing the date of birth of said registered owner, providing there is attached to said birth certificate an affidavit of an affiant who states that he or she is familiar with the facts recited. What is familiar? Let's just see what it says in Black's Law about familiar. I hope everybody's having fun, because I am. Let's see, familiar. You can already see where familiar, family. When you see familiar, you're looking at famille or family, some element of family. Or that's what I would guess, just based on the root. Let's see. Family, familiar, familia. Let's see, what is this thing here? Familiar, fair or reasonable knowledge of or acquaintance with, closeness, intimacy. Fair or reasonable knowledge. Fair or reasonable knowledge. What is knowledge? Reasonable knowledge? I know what it is, but I'm going to look it up. Knowledge. What the heck? Let's see. So K-N. Knowledge. J-K. Knowledge is a funny word. In legal land, knowledge. Acquaintance with fact or truth. This is on page 784. It also has been defined as an act or state of knowing or understanding. Do you understand the charges? No, I understand them. Do you understand the charges? It says a state of knowing or understanding. So either you know something or you agree to it. If you don't know something and you agree to it, that's pretty dumb, isn't it? If you agree to something that you don't that you don't know about, if you don't have the knowledge of something and you're going to just say, yeah, go ahead, that could be detrimental. That could be harmful to you, but you're agreeing to it. You understand? Goes on to say, page at the top there, it says actual knowledge, notice or information. And that's what I wanted to get to, the word information. When Mom signs the birth record, she signs it as informant. Informant. So what does information mean? Information. Information. Didn't I say that the form itself represents the father side of the equation? Information. Well, here's information. This is actually a pretty fun one. Information. An accusation. So knowledge is an accusation. Knowledge is information. Information is an accusation. By the way, I'm just going to tell you right now that the birth record itself is called information. So it is an accusation. It says, an accusation exhibited against a person for some criminal offense without an indictment. An accusation in the nature of an indictment, from which it differs only in being presented by a competent public officer on his oath or of office instead of a grand jury on their oath. A written accusation made by a public prosecutor without the intervention of a grand jury. In most states, the information may be used in place of a grand jury indictment to bring a person to trial. Information to bring a person to trial. That information is the birth record. Remember, the birth record identifies an individual. The individual is first, middle, last. But it also identifies what? A foundling child. It identifies an orphan, an abandoned infant, an abandoned child. Subject to who? Whoever's taking care of it. If the church is taking care of that child, they have a legitimate claim upon the usufruct or fruits of the labor of that child. Now, the church can lay claim to everything that's going on. They have their own group of guys that goes after all the usufruct. It's called the IRS. Where is the IRS located? The IRS is located in the Americas. What do I mean by that? Puerto Rico is the Americas. That's where the IRS is located. It's not in the United States. It's in Puerto Rico. The Americas. Subject to canon law. Let's keep going. Familiar. Let's stick with familiar again, because what did it say? Gosh, you'd think that I would at least put a finger in the page here and hold it. I'm not that bright. Familiar. Fair or reasonable knowledge of or acquaintance with. Reasonable, fair, by the way. I'm just going to point this out to everybody. Fair knowledge or reasonable knowledge. Fair knowledge. What is a fair? What is F-A-I-R? It's a bazaar. It's a mall. It's a place where business is transacted. It's a fair. People don't use the word anymore, but a merchant, the law merchant court is a fair court. It's a court for merchants. Merchants do what? They put their wares out in a bazaar, at a fair. That's what they used to do. They would all come together. All the merchants, maybe once or twice a year, would show up in a big open field, and they'd pitch all their tents, and they'd bring their pots and pans and their candles and all that stuff, and people would go to the fair, and they would buy their stuff. And all the merchants within the fair would have their own court system. It was called the merchant court. That's what the merchant court system is all about. It's for merchants or traders or people that are involved in trade. But, so why does it say that? Familiar, it says fair or reasonable knowledge. Fair knowledge is merchant knowledge, identifying a merchant position, a merchant vessel. So it can either be reasonable knowledge or fair knowledge. Isn't that interesting? And they're calling that familiar. Well, we're going back to the concept here. It says, state that he or she is familiar with the fact. Recited, stating that the party named in said certificate is the same party as one of the owners named in said certificate of title. So look at that. They just made it possible for either a reasonable, it says familiar, fair or reasonable knowledge, fair or reasonable knowledge. Fair knowledge identifies a commercial vessel. Reasonable knowledge can identify the chorion. They're not the same thing, but they're making it possible through the use of the word familiar to identify either a commercial vessel or a living being, or at least DNA attached to you. And it can go either way. So you go in there and lay claim to the birth record, and they're going, hey, this is fair knowledge, so now you're going in there to lay claim to a commercial vessel that's not registered or is registered to you. If it's not registered to you, then you're using somebody else's property without their permission. You probably need a license to drive that vessel. Oh, wait a minute. You do, don't you? Imagine that. He or she is familiar with the facts recited, stating that the party named in said birth certificate is the same party as one of the owners named in said certificate of title, and that thereafter the registrar of titles shall treat said registered owner. Again, registered owner of what? Are you the registered owner of the commercial vessel? Are you the registered owner of that body, the DNA? What is registered again? I read registrar, but what is registered? That's 1154. 1154, registered. Okay. Oh, yeah. Registered. Entered or recorded in some official register or record or list. This is kind of interesting. A registered bond. A bond entered on the books of the issuing corporation or of its transfer agent in the name of the purchaser, whose name also appears on the face of the bond. Either principal alone or principal and interest may be registered. It's interesting to me. It says either principal alone or both principal and interest may be registered. Well, principal is the thing itself. But it says principal alone. That would be, to me, that would be the entirety. That would be the principal in my existence is me and the chorion. So, if I have a legitimate claim upon the chorion, I become the principal. I am the principal. I'm the chief. I'm it. I have all the authority as the principal. But they go on to say, either the principal alone or both the principal and interest may be registered. It sounds to me like they split something, like there's a piece hanging out there somewhere that somebody else may have an interest in. It says a bond, the number of which is recorded by the seller in the name of the purchaser, and which only the latter, the purchaser, or one legally authorized to act for him, can redeem. Remember I talked about redemption the other day? What is redemption? What is it? To redeem oneself from where? Why is there any redemption at all? But it says a bond, the number of which is recorded by the seller in the name of the purchaser, and which only the latter or one legally authorized to act for him can redeem. So look at this. It says the latter, which is the purchaser. What does to purchase mean? What is to purchase? What is a purchase? Most people think you're buying something. But to gain a purchase is to get hold of it, to grab hold of something, to have it in your possession. That's a purchase. To possess is to purchase. Just because I give you $10 for something and then you give it to me, that's not the purchase. The purchase is when I gain control over it. That's when I have a purchase of something. I have purchase of it. I have a grip on it. Get a grip, Kurt. To have purchase is to have possession. So it says the name of the purchaser, and which only the latter, the purchaser, or one legally authorized. It says one or the other. If I'm the true owner, the sole owner, I have complete possession of something, I have purchase, and I have all the authority. But if there's a legal authorized agent out there, that means there's a secondary position. Now there's a trust. If there's two claimants, there's a trust. If there's one claimant, there's no trust. And it says that either one can redeem it. So either the true owner or some agent out there. There's the difference right there. The church has an agent, and I am the owner. The church lays claim, but since I haven't done anything properly to lay claim to that position, that secondary position, that mini-me, that piece that's been separated, that particular, that's actually been identified by deed or some other instrument, writing instrument. Down a little bit further, it says a bond with interest coupons attached is transferable by mere delivery, M-E-R-E again. Why didn't they just say by delivery? Because they're not talking about that. They're talking about by mother, a mother delivery. Okay, so that is the word register. And what is owner? Oh, of course, we all know what an owner is, or do we? Owner. Page 996. Own, to own. By the way, when it all comes together, you'll realize what this Minnesota Rule 220 is all about. But you got to hang in there and think about all this stuff at the same time. Own. To have a good legal title. To hold as property. To hold. There's your purchase right there. It says to have a legal or rightful title to have, to possess. You have to have possession in order to have a purchase. In the movie The Exorcist, it was about possession. Oh, I don't want to be possessed by the devil. If the church has the deed to your DNA in their hands, and they can actually make a legitimate claim because of that fact, you are possessed by the church. Your DNA is in the possession of the church. And the only way you get it back, what they call absolution, is when you put that little white wafer in your mouth and they give you back the body of Christ. Bend a knee to the church and thank them for giving you back your body, redeeming you from the pits of hell. The movie The Exorcist was about possession. And the Roman Catholic Church, by deed, has a legitimate claim upon your body. The missing link, the piece of you that's outstanding. That's what this Minnesota Rule 220 is all about. It's giving you opportunity to do what's necessary for you to make a proper claim upon the entirety of your estate. And you're going to put the house, your father's name, back on the land, and then you're going to have real estate instead of just personal property and land, abandoned land over there. Isn't it funny in the movie Christmas Vacation when Cousin Eddie says, yeah, they took my house and they gave me the RV. In other words, remember that when a house is jacked up off the land, and I have a good buddy that actually does this for a living. He told me a couple of years back, and I remember like it was yesterday when he told me. He says, yeah, Kurt, when you lift the house up off the ground, it's no longer part of the real estate. It's no longer called real estate. It's personal property if it's not attached to the land. When your father's name, when Kallenbach is not attached to mother's land, Kallenbach becomes personal property, a chattel property that can be traded. Now I'm trading on my father's name. Boy, that doesn't sound like that's within the Ten Commandments. Honor thy father. Hell with it. I'll just tell my dad's name for profit. I'll tell my dad's name all day long. In fact, I'm going to put it in syndication. I'm going to become a syndic. I'm going to actually syndicate my father's name. And then every time I write it, whenever I put it down, it's going to actually create money. Syndicated name, syndicated last name. That's not honoring thy father, I tell you that. To own is to have a good legal title, to hold his property, to have a legal or rightful title to have, to possess. If you don't possess it, you are possessed. If you don't possess it, you are possessed. Registered owner. To the world, when it's registered to you, they know who the owner is. They know who has rightful title to it. They will never bring a cause of action against you again. It's not profitable. They can't win. It says, as having attained. It says, the register of title shall treat said registered owner as having attained the age of majority. Attained. What is attained? Page 116 in Black Fifth. Attained. Let's see. Hang in there. I'm sometimes pretty retarded. By the way, the word retard in French just means slow. All right. Attain. To reach or come to.